The Louisiana Supreme Court hears oral argument in the Kayla Giles matter. We've got some thoughts on this next chapter in her story. Stay tuned. This is attorney Andy Marcantel and attorney Marc J. Victor from the Attorneys for Freedom Law Firm here today to talk about the next chapter in a very interesting story. How you doing today, Marc?
Yeah, I'm doing fantastic. This has been such an interesting case. Just really, I think, educational for people if they don't really get much of a contact with the criminal justice system. And, I think we probably kicked this thing off many months ago when we brought this case to everybody's attention. If you're just hearing about this Kayla Giles matter for the very first time, you might want to start with some links in our video to some of the previous videos we've done explaining what happened here. But in a nutshell, Kayla Giles was somebody who signed up in the USCCA program, and she was going through a very difficult time in her life. She was in what appears to be a sort of a violent relationship with her, what is now ex-husband, who ultimately turns out to be the victim in this case, the deceased, Mr. Cote, who she was married to. And long story short, they were having an exchange, a custody exchange of the children, and they were in, I think it was a Walmart parking lot, and Mr. Cote takes the children, puts them in his vehicle. All is said and done. Kayla Giles goes to her vehicle, closes the door. That's, I think, very important here. And then just mere seconds later, you can see on the video, which we'll also include here, Mr. Cote, for whatever reason, and we don't know, walks over to Miss Giles' vehicle, opens the door, and it's hard to see, but there's some evidence that he sort of lunged in. But whatever event, he opened the door, and at that moment, or within just a couple of seconds, Miss Giles takes her firearm and shoots and kills Mr. Cote.
Yeah.
And, at that point, the police are called. I think she's the one who calls the police and says, yeah, shot him in self-defense. She winds up calling USCCA for help. And USCCA, I think initially, to their credit, does the right thing. They spend $50,000 and hire an attorney to defend her, just like they should have done. And shortly thereafter, USCCA, as best we can tell from talking to this attorney, communicates to him that they've decided they're not going to fund the case anymore, essentially pulling the rug out from under Miss Giles and her attorney. And he told us, because we interviewed him, that he thought this was one of the best cases he's ever had in his 40-year career of defending people in criminal defense cases, one of the best self-defense cases he's seen. Doesn't know why USCCA decided to yank the rug out from under him, but they tell him he's off the case. They're not paying any more money. So Miss Giles, very disappointed, I think to say the least, maybe shocked with USCCA, is forced to hire her own attorney. And of course, she doesn't have the kind of resources. That's probably one of the reasons she joined USCCA to begin with. Hires her own attorney, tries to put her own defense together. They go to trial. I think it's important to note that she was originally charged with first-degree murder, and she goes to trial. And unfortunately for her, she is convicted of second-degree murder. And the reason for that is the prosecutor decided, after looking at the case, this isn't a first-degree murder case. We'll do our best to try to get a conviction on second-degree murder. They actually get that conviction on second-degree murder. I think what's also an interesting fact here is Miss Giles brings a lawsuit against USCCA saying, hey, you guys should have covered my defense. And USCCA and the court essentially finds that USCCA's contract says, sorry, if you commit a criminal act, there's no coverage. And since you were convicted, you committed a criminal act. I know USCCA has modified their contract, and it says, well, if you plead guilty, that's not a criminal act, and so you don't lose your coverage unless it's a crime of violence. Right. And heck, if you look at the definition of a crime of violence, what you'll find is in almost all cases where somebody would allege self-defense and take a plea, that plea is going to fit within that definition of crime of violence, which, as we've pointed out in past videos, excludes almost everybody who would be a USCCA member who would take a plea and or go to trial and lose. But this case highlights something different. This case highlights USCCA looking at the case themselves and saying, you know what, we think that this is a criminal act and therefore we're going to drop coverage. Definitely wasn't clear to the prosecutor that it was first-degree murder. They didn't even think that was the case. But that was the explanation given by USCCA for why they simply abandoned Miss Giles.
Yeah, so that is the very, very short version. And as some of our viewers no doubt are aware, there's a whole bunch of twists and turns that happen through that entire thing. I mean, first of all, we know about the actual shooting because it was captured on video. And it's not a clear video, to be fair. Lucky it was even captured at all, because I think it was from across the street at a fast food restaurant. Basically, their camera captured this grainy video. But you can clearly tell in the video, she enters her car, she closes the door, and Mr. Kuti walks up and opens her door and then falls backward. And about the representation by USCCA, which ultimately turned out to be short-lived, as you said, we talked to that attorney a couple of times, actually. He seemed like a very, very good criminal defense attorney, and he was surprised and shocked that they kicked him off the case. And we thought it was really notable that the timing he was kicked off the case was while she was still presumed innocent, before all the discovery was received by the insurance company, right? They're in the middle of discovery, and he is complying with presumably what the requirements are of his contract with USCCA, having to send them some evidence and report to them along the way. And the insurance adjusters apparently are looking at the evidence as it's coming in, and before they even receive all of it, they conclude, while Miss Giles is presumed innocent, that no, this wasn't an act of self-defense. We're just going to drop her.
Yeah, I remember talking to him about this, and he was actually very shocked and disappointed, in my view, when he received some of that evidence, which was the interview of Miss Giles' daughter, who was there at the scene and witnessed the whole incident and said that Mr. Coty actually lunged in the vehicle after he opened the door. Now, at trial, I don't know what happened. A lot of time passed between that statement and time it went to trial, but apparently she contradicted herself on the stand at trial, which sometimes happens. But that piece of evidence appears to me and appeared to this lawyer to be very relevant. And so he's trying to say to the insurance adjusters that USCCA are associated with, to say, hey, look and review this interview with the daughter, and you'll see there's more evidence of self-defense here. And according to him, they didn't even want to look at that.
Yeah, I know. And then that ultimately ended up with them dropping her. She goes to trial, as you said. She gets convicted on second-degree murder. And so now what she's been up to since her conviction is fighting this thing on appeal. And our listeners have definitely heard us talk about the appellate process before. It is a long, drawn-out process with multiple different levels, multiple courts that you have to put the case in front of. But you and I actually spoke to her appellate counsel as well. Who seems to be a very competent appellate counsel. We had some good conversations with her, talked to her about the strategy, and we got copies of her briefs as well as the state's responding brief, which we will put in the description of this video.
Yeah, Kayla Giles, ultimately, we had contact with her, and she wanted to do an interview with us, and we actually did that, and so people can click on that link on this video and review exactly what Kayla Giles had to say about this. But we did speak with her appellate attorney. She gave us permission to do that, and she shared her information, told us what the issues were. We offered to help brainstorm the case. I think she was very competent. I think people can see if they want to review the oral arguments at the Supreme Court. I think they'll come away with the same conclusion. She did a fine job. And, if you watch the oral argument, of course, nobody knows what a court is going to do. But, man, this one's got a lot of problems, and I sure would not be surprised at all if they reverse this case and remand it for a new trial.
Yeah, so let's start by talking about the process itself. Once you're convicted, you have a right to file an appeal, and that goes to an appellate court. So it's kind of, think of it as one level up from the trial court. And then if it doesn't go your way in the Court of Appeals, you can then apply for certiorari to your state's Supreme Court. And they don't accept most cases that are applied for. And the reason is they're kind of looking at the cases that are coming in, and they want to take cases that have important issues that could have more wide-sweeping public policy implications. And so this was a case that was selected by the Louisiana Supreme Court to hear because they thought there was some important stuff here to look at.
Yeah, you don't have a right to have your case heard by the Supreme Court. So when the Louisiana Supreme Court said, you know what, there's something about this case that has got our attention. We're going to look at this case. That certainly got our attention. It got Kayla Giles' attention, and so it bodes very well for her appeal. And I think that, if people watch this, then they'll get the same impression we have. I think it's important to note one of the arguments on appeal is ineffective assistance of counsel, right? She, I think, had a very competent counsel at the beginning. The fellow we spoke with, who USCCA initially paid $50,000 before they decided to pull the rug out from underneath him, and she had to hire this other lawyer who sure seems like he didn't do a very good job. I mean, there are two big issues here. Issue number one, he didn't even request for a change of venue, which you often do in a case that is very high profile, where a substantial number of people have heard about the case, have already formed opinions about the case, and jury selection is replete with potential jurors who are like, yes, I've heard about this case, I've formed opinions about this case. Pretty standard practice to try to move for a change of venue. So that's issue number one.
Yeah, just to put a little bow on that point, of the 78-person jury pool, only 17 said during voir dire that they hadn't heard about the case. So the vast majority of people who were selected randomly from the community were very familiar with all of the TV coverage it was getting, and had already started probably forming some opinions.
Yeah, we don't know what his thought process is here, and I'm going to get to this issue in a moment, but it certainly seems like most, if not all, competent attorneys would have said, you know what, very difficult for my client to get a fair trial in a jurisdiction where almost everybody has heard about this case, and several of those potential jurors have said that they formed opinions about the case, so you should have moved for a change of venue. That's argument number one, and he didn't. Argument number two is that, look, you have a situation here where you've had domestic violence going on here, and there's at least an argument that Ms. Giles is, if not a battered woman, somebody who suffered quite a bit of domestic violence. In a case like this, competent lawyers are often going to bring an expert on domestic violence. Somebody get up on the stand and say, look, this is how it affects the psyche of the person involved. These are the various influences that come up and come to bear on somebody's mind when they're a victim of domestic violence. And there was no domestic violence expert. It's important to note that in the appellate process, they did retain a domestic violence expert who gives the type of affidavits and testimony that here it wasn't testimony because we're only on an appeal, and on an appeal you're stuck with the record. But essentially you put information in the record that says, here's the kind of thing I would have testified to try to make that case that this attorney was ineffective by not using such a domestic violence expert. Now, I will add to that, it's pretty rare to raise ineffective assistance of counsel on appeal. And this is the reason, because you're stuck with what's in the record. And it's very hard to win ineffective assistance of counsel on a direct appeal, which is where we are right now. So if the Supreme Court denies any action here and they say, look, we're going to pass, we're not going to do anything, or we find no prejudice or whatever, then there'll be another motion that is brought, another hearing. We call it a petition for post-conviction relief in Arizona. And this is an opportunity to go back to the trial court and now develop the record. And so what might happen here is you would then call the trial attorney and put him on the stand and say, hey, man, why is it you didn't request a change of venue? Why is it you didn't use a domestic violence expert? And then that issue will be relitigated with the new evidence through the trial court. If they lose, they're up to the appellate court and potentially back to the Supreme Court. So while the issues are strong here, it would be very rare to have the court at this stage on direct appeal find ineffective assistance of counsel just from the record, because now they're saying to themselves, well, maybe there was some strategy reason that the trial counsel may not have moved for a change of venue or may have decided not to use an expert on domestic violence. Hard to imagine what that is, but that might be enough for them to pass on this claim.
Yeah, I get the feeling that appellate counsel at this point is just trying to preserve and argue every single thing. And you're right, procedurally it would be a little odd to find ineffective at this point just from the record. But I want to nail down the point a little bit because I think it's really, really interesting. Like you said, after the conviction occurred, the appellate counsel had an expert take a look at the case. Would have been nice for the expert to have been there to give testimony about this, but here's what the expert who looked at the case had to say. It's an intimate partner violence expert, Beth Meeks, reviewed the case, found it could not be understood without assistance of expert to provide context to Giles's behavior relating to abused women. The expert would have explained that the purchase of the firearm was related to protection given the hostile divorce proceedings going on, and this expert, Beth Meeks, also would have testified that survivors are encouraged to arm themselves to counter the state's claim that Giles had been plotting the murder the whole time. That makes perfect sense.
Right.
When you feel you're in danger, that's the time that you start preparing for a self-defense incident, and there was a lot of evidence of that, and this expert could help flesh out that point. And then Meeks also would have testified it's common for abused women to fight back to protect themselves, would have testified that emotionless reactions are common after these types of incidents. The prosecutor tried to make negative implications. Bottom line is this expert would have helped the jury to understand the conduct that the state was trying to get them to draw negative inferences from the whole time. And the appellate counsel's point in raising it as ineffective is it sure would have been nice for that to have been presented at trial rather than discovered after the fact.
It's hard to imagine how this is not ineffective assistance of counsel, and but this is why she signed up with USCCA, because she wanted competent counsel. It looks like she was off to the races with that, because the fellow we spoke to, who had been practicing 40 years at the time, seemed very competent to us. I would be very surprised if he had moved for a change of venue and tried to use an expert on domestic violence. And we certainly would have done that. Most competent attorneys would have done that. The lawyer she was able to hire with the funds that she had left over in her account that she could muster, that lawyer didn't do that. So that's an issue that's on appeal. It could get relief on this direct appeal, but more times than not, they're going to say, you know what, bring that thing in a petition, develop the record, put that attorney on the stand, ask him why he didn't do those things, and let's see what he says.
Yeah, and I wasn't surprised to see the judges during the oral argument focus the things that the record already supported. We should talk about a couple of the other legal errors that are alleged here. One of them, I think, which is really interesting, is refusing to strike two of the jurors specifically for cause when there was adequate cause to strike them. And, you know, our audience, maybe who've watched our Fighting the State series where we talk about the voir dire process, understand that there are two different types of strikes that are typically employed in different jurisdictions. One of them might be what we call a peremptory strike, and that's where we get to choose who to strike. We don't like that person. They answered something, and it's what they said wasn't quite to the level of, like, we have a legal reason to strike them, but we just don't like that person on the jury. And both sides have these peremptory strikes in these types of jurisdictions, and so you can choose to strike people. But then there's the other type of strike. This is where the judge needs to get involved. This is called a for-cause strike. This is where somebody says something that totally impedes their ability to be impartial and do their job as a neutral juror, as a neutral fact finder. And there were two jurors specifically on this jury that looked like they should have received that for-cause strike, but they didn't. And so the defense ultimately had to use their peremptory strikes on what should have arguably been for-cause strikes.
Yeah, this is a very important point. I mean, look, you get unlimited strikes for cause, right? If you are picking a jury, and when we pick juries, we look at them, and if somebody says something that causes us to say, I don't think this person can be fair. Like, for example, I've already formed an opinion that she's guilty, right, or something along those lines, which is indeed the kind of statements that were being made here. Oftentimes what happens is the other side will go and try to rehabilitate that person. They'll say, well, look, even though that's your position right now, could you put that aside and listen with an open mind to the evidence? And the person might say, yeah, I think I could do that. And so then they'll argue, well, okay, the person said they could be fair. Sometimes they say, no, I don't think so, in which case it's an easy strike for cause. So what happened here is you had two people who made those kinds of statements that would cause a reasonable attorney to say, you know, this person really can't be fair. I move to strike them for cause.
Let's pause here to talk about what those statements were during voir dire, because they're pretty wild. So one of the jurors said, I actually worked at the store next to the Walmart where this occurred. I watched and read extensive pretrial coverage, most of which was negative towards Miss Giles. I read social media posts about it. I discussed the case with my family members. I formed opinions on it. On voir dire, he said, I believe that she's guilty.
Doesn't get any worse than that.
Not even done. In fact, I know the deceased. I know Mr. Cootie through work, and he had bought stuff from my store, seemed like a decent guy. He said, I've been influenced by social media, and I have formed an opinion based on that influence. And then when asked at the end, but could you set aside that to do your job? He said, yeah, I think I could.
Right. So this is the kind of situation, right, where really, to me, a judge should say, look, you made such strong statements about the fact that you're biased, that you ended it with, yeah, I think I could put all that aside, isn't enough.
Let me say the other one real quick. These are just, it's crazy to me that these weren't for-cause strikes, Mark. I heard about the case from friends discussing it. Then I started reading all about it on social media. I started talking to my friends and saw everything reported. I followed it on the news, most of which was negative coverage from Ms. Giles. My mother was at the Walmart that day. I have close mutual friends with the deceased. I can tell you that the deceased, from everything I know about him, was a great guy and a wonderful father. I could not apply stand your ground laws as written. That one's an interesting one because they say, can you apply stand your ground laws? You're going to be required to follow the law. He said, I can't. And then they pressed him a little bit and I said, I'm normally a law follower, but I need more information to know whether I could apply neutrally the stand your ground law. They didn't strike him for cause, which is wild.
And they never got him to back off on that particular statement, which is unsure about whether I can follow the laws given to me. So what happens here is defense attorney moves and says, hey, let's get rid of these people for cause. And it's argued out, and the judge says, no, denied. So now the defense attorney has to reach in his pocket through his very limited peremptory strikes and use two of them on two people who should have been struck for cause. That's the prejudice, right? Because you were supposed to get a certain number of peremptory strikes, and you didn't get them because you erroneously had to use two of them on potential jurors who should have been struck for cause and weren't. And that's prejudice in many jurisdictions.
Yeah, so to anybody who says, well, what's the problem? The two guys didn't end up on the jury anyway. They shouldn't have had to clean up the court's mess. The court was required to step in, and they could have used those other two preemptories to get a better jury, presumably, for Ms. Giles, and had to clean up a mess, a legal error, and rather than strategically whittling down the jury to people who would be more favorable to the defendant.
You were robbed of two strikes.
Yeah. That's all there is to it.
That's what it was. And so that's an issue on appeal, and you can decide that one based solely on the record, which is maybe unsurprising. They don't have a lot of discussion about this at oral argument, and which is very common, right? I've argued many cases on appeal myself, and you often have many issues in the brief, and the justices want to focus on one or two issues. And sometimes they don't ask any questions, and so you just never really know. But they could decide this case on that particular issue, even though they didn't even mention it in oral argument.
Yeah, what they really focused on in oral argument, what a vast majority was dedicated to, was this idea of the aggressor doctrine being presented in the jury instructions to the jury. Bottom line is that Ms. Giles was claiming Louisiana's stand your ground law. And the stand your ground law basically says, look, if you are in a house or an occupied vehicle, and somebody attempts to enter that vehicle, then that opens up what you are justified to do. You're allowed to use justifiably deadly physical force to defend yourself when the aggressor is opening your car door and attempting to make an entrance, and we'll talk about that term because it kind of came up a bit as a hot-button legal term, entering a vehicle. But the idea that the defense was purporting was, look, the guy opened up unlawfully her vehicle, and she had a right to use deadly physical force because of the stand your ground law. But what was also given to the jury was this idea of the aggressor doctrine. And so what the aggressor doctrine is, a lot of our viewers have probably heard us talking about it. If you caused the problem, if you were the primary aggressor in that interaction, you don't get to rely on self-defense.
Unless you retreat. You say, you know what? You communicate your attitude, which is, I'm done. This is over. I'm trying to retreat now. And then the person who previously was the victim of your aggression now turns into the aggressor. Now you can claim self-defense. So really the crux of the issue here is what Ms. Giles is arguing on appeal here is that aggressor instruction should never have been given because there's no evidence that she was the aggressor. What, of course, the state relies on are incidents that allegedly occurred far earlier in time, weeks or months earlier in time, where, well, you know, she bought a firearm, well, she signed up in USCCA and got their insurance coverage. Well, she made statements about whether this was off the cuff or not, and the person she made the statement to was very clear in saying, I didn't take this statement seriously, with something along the lines of, oh, I'm going to kill him, or I want to kill him, or something like that. Again, the person who heard the statement said, I didn't take it seriously. So they try to use that and sort of bootstrap that in to say, well, here she was the aggressor, and there's enough evidence that a jury could find that she was the aggressor and had a duty to retreat. The argument from Ms. Giles' attorney here is there is absolutely no evidence at the time that's relevant, which is at the time of the shooting in question, that she was the aggressor. Also, one of the justices, I think, makes the very astute point, to the extent that these things happened at all, none of them were even communicated to Mr. Coty. Mm-hmm. How can she be the aggressor if he's not even aware of these earlier statements or acts? It just doesn't make sense. And so if that instruction was given in error, could be reversible error here in the court. I encourage people to watch this argument. I mean, other than maybe some comments made by the Chief Justice I wasn't totally impressed with, most of the comments by the justices there, I think, were pretty on point. I think they're very interested in this issue.
Yeah, there's a few clips that I want to take a look at, but let's take a minute here to explain why this is so important, that the jury instructions were given properly. This is a very ripe area for reversible error. Reversible error is where you get a brand new trial because the idea is that the proceedings were so screwed up that they weren't administered fairly. There was no way that the jury could deliberate properly if they got the wrong instructions, right? And so the idea here is that you gave them something that doesn't apply, that there is no evidence of whatsoever that she was the aggressor. In fact, all the evidence seems to contradict that in the moment that it mattered, she was definitely not the aggressor. And so the attorney's point, and I think we should show the clip of her summing it up here, is basically saying that we can't give jury instructions off of pure speculation with absolutely no evidence in the record, and she's right.
Yeah.
And so in this
we're
case,
talking about a legal question there, and that is the interrelation between the stand your ground law and the aggressor doctrine.
yes.
And if you are relying on the stand your ground law, does the aggressor doctrine even come into play?
It shouldn't. It shouldn't unless there is evidence. A jury instruction should only be given if there's evidence presented at trial to support it.
So what you're asking real quick so that I've got the right mental framework as I listen to the rest of the argument, what you're telling us is not that we should step in and supplant the jury's views of the inferences. You're telling us that there was legal error that infected these proceedings in the jury instructions, and that's why we should reverse and remand for another trial.
Correct. And there's two major legal errors. There's error in giving the instruction itself, which wasn't based on any evidence. You don't get jury instructions based on hypothetical or speculation. And the only thing that my colleagues on the other side have ever pointed to at trial and in their briefing, and what the Third Circuit relied on to support the giving of the aggressor doctrine, was that the act of drawing a gun in and of itself is an inherently aggressive act.
So I'm glad that they spelled that out very clearly at the beginning. The justice knew the importance of spelling that out. Notice here the deference to the jury. The idea is that an appeal is not a time to say the jury got it wrong. We have a jury system in this country, and we want to give great deference to the jury. But the idea here that's being, I think, very effectively argued is that the jury, no matter how effective they were, if they were given the wrong rules to dictate what they needed to decide, there's no way they could get it right. This is a legal error that, as that judge put forward, infected the proceedings.
Yeah, sometimes you're stuck with arguing the jury got it wrong, and you're really sledding uphill there. But this isn't one of those times. I think what she said was interesting, that the only evidence that they're saying Ms. Giles was the aggressor here was that she had a firearm in the vehicle. So what? I mean, she had every right to have a firearm. She was legally in possession of the firearm. I know there's some evidence out there. There was an order of protection. But my understanding of that is nothing was said during that order of protection hearing that had anything to do with any firearms. And maybe more importantly, it was never served on Ms. Giles, and therefore wasn't effective. So she was not a prohibited possessor. She was legally entitled to have that firearm in her vehicle, in her hand at the time that he enters the vehicle. I also found it kind of funny, if people watch this argument, that counsel for the state kind of says, well, they sort of invent the possibility that somehow Miss Giles provoked Mr. Coty to actually come over and open the door. Like, she somehow planned to act in self-defense and somehow got him to walk over to her vehicle and open the car door. Like, how do you get somebody to do that?
Let's watch that clip because I thought that was a really notable part of the argument.
What evidence is there of provocation?
That's a
That's a stretch.
What evidence of provocation is there?
What you have is the evidence based in the history between the two parties.
How is the history relevant when you've got the whole thing on video?
You've got, like I said, something from a distance on video, and you have no audio of the altercation.
Nobody disputes this is the victim walking to the defendant's car, correct?
Correct.
Couldn't the children had already been exchanged and were in his vehicle?
Yes.
Could he not have gotten in his vehicle and driven off?
It's not clear what actually took place after that happened.
But there was nothing to prevent him from just driving off.
That we are aware of, but as evidence was also adduced, there is reason to believe that the defendant was armed with the pistol prior to the victim opening up the car door.
You think she threatened him, don't drive away?
Ultimately, that was a question for the jury to decide.
After being threatened, don't drive away with a gun, he walks over to her car? That's just nonsense. He could have driven off. If he wanted to talk to her, he could have called her on her cell phone. If he really wanted to talk to her that badly, he could have walked over and said, please roll your window down. Instead, he reached out and opened the door of her vehicle, correct?
That's what the video depicts.
Somebody comes and opens my door of my vehicle, I may shoot him too.
Bam.
Pretty powerful.
Wow.
Yeah.
To have a justice on the Supreme Court make that kind of a statement, hard to imagine he's not going to be pretty friendly to Miss Giles' point here. One thing's for sure, this is not absolutely obviously clear that a first-degree murder was committed here. That was just hogwash.
Yeah, I couldn't agree more. This is the point that I have been saying since the very beginning of this case, which is if the idea is that she planned for the whole thing to happen, how on earth did she get him to come over to the vehicle? The interaction ends over at his car. She goes to the car, closes her door. So the theory here is that, I don't know, did she use mind control or psychology or something like that and planned for him to not only angrily walk over, but to grab the door and open it up? I mean, it just has made no sense to me since the beginning, since we've been analyzing this case. There is no evidence of any hypothetical like the ones that he's given throughout this oral argument. Well, we don't know, but a jury could find that she did something to make him come over to the car and open the door. And as the appellate attorney correctly pointed out, you don't get jury instructions based on total conjecture with no evidence in the record whatsoever.
Yeah, I mean, look, we don't know what's going to happen here, right? You could try this case 20 times and, have a pretty interesting split on how many times a jury comes back with a guilty or a not guilty. But to say at the very beginning of this case that this is absolutely clear case of first-degree murder, and we're not even going to defend the person on this case because they committed a criminal act, that just seems outrageous to me. And I can understand why people who are aware of this case and who are members of USCCA say, you know what they did in this case doesn't make me feel comfortable that they're going to look at my case someday if I'm ever in that position and not come to exactly the same conclusion. I think it should go without saying that a case like this comes in and you're an attorneys on retainer client, there's a 100% chance that we're going to handle this case. We're going to do it enthusiastically and give the best possible defense that can be given in a case like this. I can assure you we're going to move for a change of venue, and we're going to use a domestic violence expert at the trial as well.
Among several other experts, probably. But going back to the state's theory here, which has always been very strange to me, it's that look at all this shady stuff leading up to it. So therefore, we're requesting an instruction that she's the aggressor in this particular incident. State's counsel starts making that argument again, saying basically, look, the aggressor doctrine was justified to give to these jurors because she did a bunch of crazy stuff in the past. And he starts making that argument. You can tell he's losing some of the justices here.
As he should be.
The documented history between the parties. Now, opposing counsel mentioned that there was a documented history of violence or stalking by the victim towards the defendant.
Why does that affect the aggressor doctrine in this particular incident?
Because if one party, and in this case the defendant, Ms. Kuti, we have established that she was planning to do the murder, that there are prior instances of physical violence committed by her against the same victim, and a recording of that same defendant attempting to provoke the victim into some sort of reaction or altercation. There was a recording of that played for the jury. When you have items and evidence such as that, it would be reasonable for a jury to believe that it's possible, if not likely, that Ms. Kuti did something or said something to bring on an altercation.
What evidence is there of provocation?
That's a
stretch.
I agree. That is a stretch.
Wow. Look, I think what's an important point here is the family court specifically found that Mr. Kuti was a credible threat to Ms. Giles. We got to accept that as a finding. Well, what is it reasonable for such a person to do? I think it's reasonable for such a person, and especially if there's evidence that Mr. Kuti is showing up with a firearm for the exchange of children during these custody exchanges, for her to be armed so she's not a victim, so she goes out and buys a firearm. It's reasonable for her to actually seek some training and try to understand what the law is. For them to try to turn everything into a pre-planned murder is just ludicrous, because the one fact that I think they don't overcome is how do you plan to get him to turn around and walk to her car and open the door?
Yeah, like, say, let me give you a hypothetical. Like, imagine if you had absolute rock-hard evidence that somebody had planned to kill somebody. Just like there's a manifesto, like a point-by-point plan, bullet pointed of exactly when they want to do it and everything like that. Grant that. Grant that. I don't think the evidence in Giles's case even close to shows that. That's what the state's arguing. But grant that. Even then, in that situation, you're assessing it in terms of, is he lawfully entering the vehicle or is he not lawfully entering the vehicle? What is she allowed to do under Louisiana state law? What is she not allowed to do under Louisiana state law? Even if you plan somebody's murder, you still could in that moment be acting with valid self-defense. So it's just ridiculous that they're pulling up all these older things to try to say, oh yeah, that justifies the aggressor doctrine in this case. It has never made sense to me. I've never understood how anybody could think that this is obvious first-degree premeditated murder for him to walk over because she's used mind control or psychological tricks or something like that. I just don't get it, Mark.
Look, if there's one thing that's clear, this is absolutely at least an arguable case of self-defense. This is a reasonable assertion of self-defense. This to conclude before you've even tried the case, before you've even seen all the evidence, that this is absolutely a clear case of first-degree murder, and therefore we're not going to cover the person, is outrageous.
Yeah. Let me point out something on that point, right? Because what you just did is you talked about, look, when you find somebody's a credible threat, it is reasonable to get some training, purchase a firearm, be prepared in those situations. See, that's a positive inference that you're drawing from it. You're looking at it, trying to draw it in the most positive light possible. You could also look at it and attempt to draw a negative inference from that. It's really open to interpretation. What you don't want is the people who are supposed to be advocating for you and deciding whether they're going to cover your case to look at them and try to draw the most negative inferences that they can from that chain. You want them to be doing what we're doing right now and saying there's positive inferences that are reasonable that can be drawn from all of her conduct leading up to this incident.
You know, Andy, it's a great point, and it's one we talk about all the time, right? In the absolute crystal clear case of self-defense, almost never is there going to be a charge. If that's what you're looking for, you're almost never going to have to defend a case. Almost all of these, at least, are arguable cases, right? It could go one way, it could go another way. If you're not going to cover people in arguable cases and just say, well, let me take the negative inferences. I mean, I could draw positive, I could draw negative. Let's take the negative.
Choose to just agree with the state. Like the people who are assessing her case are like, yeah, I'm going to agree with the state's negative inferences and disclaimer. That's crazy to me.
Absolutely crazy. So I hope people really check in. I hope they watch this argument. I hope they go the right way and reverse this case And we'd certainly love to be involved. This is a case we would love to try. I know that Kayla would love for us to do the case if it gets reversed. It's a case we'd love to do if it gets reversed. Nobody ever knows how a case is going to come out, but certainly we would, like we do with all of our cases, fight as hard as we could fight exactly the way we'd want someone to fight for us, and then see what the jury does.
Yeah, we've actually become friendly with Kayla since the incident. We've had her on the podcast once, and she'll send us stuff from the prison every now and then and send us some through the inmate messaging system. So she sends us documents. She sends us messages. And so we've become friendly with her, and we would be absolutely foaming at the mouth for a chance to get this thing. If it were to be remanded, reversed for a new trial, we would absolutely love to be involved, obviously. But there's one more clip I want to play. I think that the judge is making a very good point here in talking about Louisiana's stand your ground laws.
Counsel, before you go there, does she not have a right under the stand your ground to arm herself at that point?
If the individual that she shoots did indeed unlawfully try to enter her vehicle.
Well, I mean, is there any question about that he tried to enter her vehicle unlawfully?
I think certainly, Your Honor.
Okay, so if we concede that he tried to open her door unlawfully without her consent, does she not, under the stand the ground law, have a right to arm herself in that vehicle and use deadly force if necessary?
First, even assuming that it was conceded that the pulling of the door handle was unlawful, there's nothing in the video that depicts the victim trying to enter that car.
Well, why would you...
Wait. His hand's on the door and opens the door.
But opening a door does not, one, make an entrance. That's simply the opening of a door.
Well,
That's another
my question is that, so you're saying that he can open the door and she has to wait till he gets in the car to shoot him under the stand the ground law, or can she defend herself if she's lawfully in a car, has a right to arm herself under the law, and he opens her door, and I can't think of any other reason to open the door except to get into the car, then at that point does she have the right to use the weapon?
This individual would have to pose a reasonable threat to the shooter. And that's the problem with what you've heard from opposing counsel today. There is no documented evidence of the victim being an abuser to the defendant. No documented history of stalking, no documented history of him carrying a weapon at child custody exchanges. This is all from her mouth.
Right, other than her testimony.
Other than her testimony.
That was accepted evidently by the family law judge in order to issue the restraining orders. He must have given some credence to it because he issued a restraining order.
Well, this is an absolutely clear case of first-degree murder.
No, I mean, it's now he's quabbling over the definition of entering the vehicle. The judge very correctly points out, does she have to wait until he crawls inside of the vehicle?
Gotta wait till he puts his hands around her throat and she's on her final last breath. It's just ridiculous. And so, look, I hope these justices on the Louisiana Supreme Court do the right thing and remand this case and give her another opportunity to try this case without that erroneous instruction. There's no evidence that she was the aggressor here. Whatever she planned, however you want to interpret it, that was far earlier. That is not this incident. And you are judged by what you are doing at the time the incident is occurring, not what you've done earlier in your life. It just seems ridiculous to me. So hopefully we'll just have to wait and see what they do, and we'll keep people posted on what happens with this and where it goes from here.
Yeah, it's tough to get cases reversed on repeal. As we always tell people, it's better to do it right the first time than try to be working uphill, essentially, where all of the appellate laws and all the jurisdictions are really designed to keep convictions in place and give a lot of deference to the lower courts. But even that said, I think that there are some excellent issues that were raised here by her appellate counsel. And like you, man, I'm on the edge of my seat. Can't wait to see what happens with this one.
Yeah, stay tuned. This is an update on a continuing story.
All right, everybody. Thanks for tuning in today to this video. Go and check out attorneysonretainer.us to learn all about our self-defense program and what it can do for you. Check out attorneysforfreedom.com to learn all about our law firm and how we defend people in the criminal justice system. As always, if you liked the video, be sure to leave us a comment down below, throw a like on the video, share it with a friend, and subscribe to the channel. Until next time, this has been Attorneys Andy Marcantel and Marc J. Victor, signing out.
Peace.